we'll get started. You'll start admitting people, right? Okay. Hello, everybody. My name is Smita, and we are back with the KelpHR and ILA session yet again. And this time it's like an open mic session. Ask us anything. Ask us anything on this subject of prevention of sexual harassment at workplaces. I know there have been a lot of questions, and I get asked at least one or two questions, which is really a googly all the time. Yeah, so we are trying to answer as many questions as possible today. So we had sent out this link, and with that, we had requested people that if they have any questions, they can send it to us directly. But on this call today, whoever are there can also ask us their question. They can put it on the chat, or they can unmute themselves and ask the question, and we will have our expert panel here respond to it. So let me, before I get started, I hand over the mic to Madhura, who will explain us about ILA.
Yes, thank you, Smita. Hi, everyone. My name is Madhura. I represent Indian Lawyers Association. We are a non-profit, all India-based organization which runs through different cities. They're called as chapters. So we have about 70 plus chapters in India. And all our chapters are independent. They run their own show, run initiatives. Initiatives could be in educational form, social form, cultural. They even come together, celebrate festivals, they organize events, webinars, and all of that. So we are a totally welcoming body. Any legal professional can join us. Just get in touch with us. We'd be happy to help you either form a chapter, be a part of an existing chapter, and just figure out what role we can play together. So I'll hand it back to Smita, and I'll send a detailed email to all of you soon about what we do, how you can join us. Thank you.
Thank you. Thank you, Madhura, for that. So let me take the privilege of introducing the eminent panel. We have with us CJ Jovson. He has a bachelor's degree in psychology and in law. He's a tech-savvy advocate practicing on original civil, criminal, and commercial jurisdictions of Bombay High Court and courts subordinate to it since the last 15 years, and the Supreme Court of India, Kerala High Court, Goa bench of Bombay High Court, Ahmedabad and Calcutta since 2016. He's also presiding as an arbitrator of commercial causes since 2018. Jovson is a visiting faculty at MIT University Mumbai campus. He has a special knowledge in the areas like ADR, constitutional law, medical jurisprudence, forensics, interpersonal relationship, and conflicts at workplace and home. Welcome, Jovson.
Thank you.
Okay. With us, we also have Vaishali Bhagwat. Vaishali is the first lawyer in the country who was selected in TCS Shivning Scholarship Program on Cyber Defense and International Collaboration on Cyber Police by British High Commission and Tata Consulting Services. She's a practicing civil and cyber lawyer with 24 years of experience in litigation and advisory practice. Her work includes civil, commercial litigation, property law, employment law, family law, succession, and will. She specializes in cyber law, and her work also focuses on law relating to violence against women and children. Vaishali is an advisor to several companies and is on the advisory board of several chambers of commerce, Maharashtra State Commissions of Women, Maharashtra Cyber Police for Legal Reforms, and Board of Studies for Symbiosis Center of Distance Learning, Symbiosis Skills University, and Surya Datta University of Cybersecurity. So welcome, Vaishali, too. All right, so let's get started. Anybody on this call wants to start, or should I get started with the list of questions that I have already got? And maybe y'all can think about any questions and table it. So Jovson, the first question comes to you. Opting for conciliation after inquiry has begun. Can it be done? So generally what happens is, just to give you a background, we actually had a case where a lady first said that she wants to go in for conciliation. She gave it to us in writing. And once we started the conciliation process and we spoke to the person, the respondent, the lady comes back and says, oh no, you know what, I want to do a full-blown inquiry. So what do you recommend? Is it possible, first of all? And do you think, is it a best practice also? So we would want to hear from you. What do you think about it?
Conciliation is an effort at settling the disputes amicably.
Yeah.
As far as settling the disputes amicably is concerned, there is only one hindrance, which is provided under Section 320 CRPC, which gives a list of offenses which are compoundable and which are non-compoundable in nature. If the sexual harassment complaint of has crossed the limit of compoundability, for example, it's taken the form of I'm getting disturbances.
Really sorry, Joseph, go ahead. Request all of you to put yourselves on mute. Thank you, Vaishali, for joining in. Joseph,
if the allegations have crossed the limit of compoundability, or it has actually committed an offense which cannot be compounded, then in such a case, conciliation cannot succeed. You may consider conciliation, but if you find that the allegations are very serious, then you have no right to bring a closure. It should be reported to the legal authorities. Otherwise, conciliation can be played at any stage of the inquiry.
right.
Like if a parties want to amicably settle the issue, courts always allow, whatever the stage may be. It's like that.
Oh, that's really interesting. That conciliation can be because we have got a lot of input saying once we start the conciliation process, the other way around, the full-blown inquiry won't be possible. So what do you think about that?
If the conciliation has failed, if the conciliation has failed, and in the conciliation process, it is found that the woman has admitted that it's not the issue is not as big as she alleged, then it is unjust and unfair to go on with a full-fledged inquiry. When you say full-blown inquiry, I would like to take offense of the term. Full-blown is not a good usage. Full-fledged inquiry, you should say. Yes.
Inquiry. Thank you for correcting me. I see a question asking, what is a conciliation?
You want me to answer that?
No, I can respond. Vaishali, do you want to take?
Yeah, hi everyone, and I'm sorry to have jumped in a bit late. So I'll take this question up as what really is meant by conciliation. So if I have to put it in simple words, conciliation is a process where two parties are encouraged to reach a settlement by a conciliator, and here the committee who will facilitate this settlement between the parties. Another word I can use for it is negotiated settlement.
Thank you.
So Smita, can I just expand on that a bit?
Yes, please go ahead.
What it means under law is that there is no acceptance of allegations, or so I'm not saying because I'm guilty, I'm ready to get into a settlement, or because I've not done that, I demand a settlement. So under a conciliation, the merits are never discussed. The merits are never confirmed. It is just a settlement that is arrived at by both the parties, and the committee will not offer advice or solutions. We as mere facilitators, where is that you can reach a point. You can't say take an apology letter or ask him for we'll demote him,
So that sort of advisory role is not played by the committee, is what is conciliation.
Awesome, Vaishali. There are times when, I'm just going to expand this. There are times when a complainant asks for conciliation, says that I want to do a conciliation, but I want this person to be terminated. So what would be, I mean, generally they say in conciliation, it is a mediation. So two parties sit across each other and debate it out, or come to a, I won't say debate it, come to an amicable solution. But there are times when the complainant says that while I'm okay for conciliation, but my condition of conciliation is that this person needs to be terminated. Any puts
So
from?
I don't think that is, so it's not, you can't demand a settlement. And that is why it is what we call it as a negotiated settlement. She can put across a demand, and you can't say conciliation can be started only with this condition. This condition can be placed before by her to him, saying that if you resign, then I will not press charges, and that will be recorded as a settlement. Very unfortunate if that ever happens. And that is why an IC should never be a party to such conciliations, and that has to be recorded in a very independent manner. That's my opinion on this.
Right. Thank you so much for that input. Next question, Vaishali, comes back to you. What happens if IC takes longer than 90 days to close the inquiry? Because we have been given 90 days. Just for the sake of audiences, I'll explain that IC gets 90 days to complete a particular investigation and 10 days more to do a report writing. What if in some situation, because of maybe IC's unavailability, or there could be multiple other reasons, IC takes more time, then what do we do?
So 90 days is not like it's an engraving on a rock.
Yes.
90 days is a recommendation given under a legislation so that the inquiry happens in a prescribed period of time. An IC may avail of an extension for various reasons. All those reasons should be reasonable, though that's a very lovely word. So what could be reasonable? That witnesses are not available in a given time frame, or IC members have not been available for justifiable reasons. If a certain IC member is not available for long, then has the committee taken steps to replace that member with another member? So as long as the committee is able to show that they have taken adequate measures to ensure that the inquiry has progressed in a manner where everybody has been diligent, then this allegation that the inquiry was not completed in 90 days cannot come as a non-compliance. So of course it is extendable, provided it is supported by a reasonable justification.
Awesome, thank you. Jovson, you have anything to add here?
The popular phrase is, for reasons to be recorded in writing, the time can be extended. That
Great.
is how they write.
We'll quote unquote this. All right, now right back to you, Jovson, for another question which came up to us is, can there be a gender neutral policy, and can IC look into the complaints from the persons of other genders?
See, there is no bar to it. If the allegations are of this nature are high, then there should be an inquiry conducted which should be gender neutral. As far as the PoSH Act is concerned, it is not very specific that it's only for the purpose of women. Although it's enacted, the genesis of the act is for the empowerment and protection of women. But in a given situation, I'm of the view that this act can be invoked.
All right. Thank you so much, Jovson, because today I was in a conversation with one organization. So as soon as you say the Sexual Harassment of Women at Workplace Prevention, Prohibition, Redressal Act, the women word becomes an concern, and immediately, because immediately the questions start coming in that why only women, why not men? Okay,
Because in 2A of the Act, it contains only aggrieved woman, not aggrieved man.
Vaishali, you have anything to add here? What? Sorry, Joseph, you're saying something.
Aggrieved man is not there. Aggrieved woman is there in that Act, in Section 2A.
Right.
So let me answer this very concisely. This law was enacted for protection of women as a gender from all forms of sexual harassment. So the victim has to be a woman. There is no scope for interpretation over there. The victim has to be a woman, either working in that organization or outside that. That's not of any relevance. The perpetrator could be anybody. Could be a man, a woman, a transgender, or any other gender. Now, having said that, the question is this, can the IC look into complaints, or can the policy be gender neutral? And you'll have this question coming up in a lot of organizations, because organizations, and very rightly so, want to send out a message to employees that our workplace is safe for all genders, irrespective of who you are. So policy can be gender neutral. My advice is that it has to have two sections. One which says that these are the powers of the ICC which are available under law, and that is the PoSH Act, because the committee gets statutory powers, like powers under the civil court, powers to even arrest, attach property, ask for evidence from third parties. These are powers that ICC get under statute. And this is the specific statute. So only when the victim is a woman, the IC will be able to exercise these powers. When the victim is a man, IC can take up that inquiry, but not under exact provisions of this act.
Section,
That
I would like,
bifurcation has to be very well made out in the policy.
I would like to add one thing here. Section 14 of the Act is an attempt at making it gender neutral. It provides for punishment for false or malicious complaint and false evidence. I need not read out, if you want, I can read out the section. It says that where the internal committee or the local committee, as the case may be, arrives at a conclusion that the allegation against the respondent is malicious, or the aggrieved woman or any other person making the complaint has made the complaint knowing it to be false, or false, or the aggrieved woman or any other person making the complaint has produced any false or misleading document, it may recommend to the employer or the district officer, as the case may be, to take action against the woman or the person who has made the complaint. So this, in my view, is a gesture at making it gender neutral, although the Act, short title of the Act says that it is sexual harassment of women at workplace. It takes care of sexual harassment by women also, although it is sounding of women.
Yeah, it's very specific for women employees. And one recommendation that I give to anybody who asks me, saying that when you're crossing a road, you know that you have to stop at the red signal. So this law is basically the red signal, but organizations can extend its policy for all kind of genders, and you can stop at amber, right? It's the best practice to stop at amber light. So that having said that, we always say that, and as Vaishali mentioned, have two sections, and statute covers women victims. So, use that. And of course, under your code of conduct or grievance redressal policy, handle the men related cases, right? So this is something that we say, and we ensure that people are taken care of. And I think we are on the right path, is what I hear. The next question, right back to Vaishali, I come. Can gender-based discrimination be termed as sexual harassment? Now, issues, Vaishali, is that sexism at workplace or discrimination based on your gender. There are many such cases that happen which does not have a sexual connotation, right? But can that be termed as sexual harassment, and can IC look into these cases?
So let me just maybe give a few examples, so just to understand what is the difference between, say, pure gender discrimination and predatory behavior, because that's where the thin line is. When we say gender-based discrimination, one can say, see, you don't go out after 7 for work because it's unsafe for women to travel to remote places. And then that woman may say that that's unfair because then I'm losing out on a particular opportunity or doing a particular kind of work. So that definitely will be gender-based discrimination. And I don't think that is, my personal view is it is not sexual harassment, but it's definitely discrimination based on gender. Or there could be examples like in a team meeting, somebody is making comments generally about women either being very good at a particular job or not good at a particular job. Or expecting perhaps in a more conventional setting, if a tea tray is being served, a woman should get up and serve the biscuits or pass around the tray of biscuits, or it can be like very normalized behavior otherwise, but that could be an expectation, or an expectation that pretty women in the company should go up on the dais and present flowers to guests, is a very subtle form of, say, gender-based role, if I can say, and it may not go down well in a very, if you want to actually promote inclusion and diversity. So these are examples of gender-based discrimination. But if I have to say sexual harassment, which also can appear like a gender-based discrimination, is where a male manager is trying to go out of his way to help a female subordinate. We did deal with one case where, he was like overly helpful, helping her find an apartment or buy a car, or helping her or teaching her how to do investments. And she kept saying that, I feel suffocated, I can do these things on my own. And then she actually decides to leave the job because it was getting so suffocating. And because she decides to leave the job, suddenly his behavior towards her changed. And he said that, you're never good at your work, and we had so many issues of handing over. And that is the time she came and said, now this I want to complain as sexual harassment, because obviously the motive was something else than merely wanting me to help me as a manager. And there we actually did conclude that it was predatory sexual behavior, which did create a hostile workplace atmosphere. So it's a thin line, and it will be based on a lot of facts of every case. But all gender-based discrimination is not sexual harassment.
All right. Thank you, Vaishali. Joseph, you want to add anything here?
The section 2N of the Act, which says sexual harassment, it's an inclusive definition, not an exclusive definition. It gives 5 items, which may also include. So there could be many other things which we can, if we feel is a sexual harassment, can be added into it. And section 3 of the Act, which deals with prevention of sexual harassment, that in subclause 2(1), it says that implied or explicit promise of preferential treatment in her employment, that also is considered to be a sexual harassment, or implied or explicit threat. So it covers both implied or explicit promise of preferential treatment, or implied or explicit threat of detrimental treatment in her employment, or implied or explicit threat about her present or future employment status and interference with her work, or creating an intimidating or offensive or hostile work environment for her. What is hostile for her? The woman is free to choose. The man's advances, which are seemingly friendly, she can treat it as hostile, as like my friend Vaishali said, that if he's too much protective, too much intervening, that means she can take it as a hostile environment, and she will think that he's a creep, I better leave. So these things are amply provided in the Act.
Thank you, Joseph. Joseph, I come back again to you, and we discussed about this. If management feels that IC is not active, then or the presiding officer is not too efficient, is there any provisions for the employer to take any appropriate action against them? Yeah, mind you, they are saying they are not active or efficient. They are not saying that, they have violated the law or anything of that kind. They are just saying they are not active or efficient.
See, they're not active means they are not of any use, or their continuity can cause us more harm. If there is no harm, there will not be any place for complaint.
Yeah.
So they are not doing anything negative, but their idle positivity is not giving us any positivity.
And they are there, but because of non-action, there could be an issue. Okay,
Yes,
so
omission is very much a crime. Omission to act. I'll just take you to a provision in the law. Just now I had taken it out. It's regarding the removal of chairman.
Removal of an IC member. Yes.
Yes. I'm sorry for keeping you waited.
No problem at all.
There's a specific provision in section 7, which consists of which is talking about composition, tenure, and other terms and conditions of local committee. In that, from subclause 3 onwards, subclause 3 of section 7, subclause 3 says where the chairman or any member of the local committee contravenes the provision of section 16 or has been convicted. Now your question is not about being convicted, or has been found in any disciplinary proceedings, or a disciplinary proceeding is pending against him, or has so abused his position as to render his continuance in office prejudicial to the public interest. Now, what is the public interest? Public interest is a subjective term. In an organization, public interest means the interest of the persons in the organization whose fates are in the hands of such chairman, chairperson, or member. So here, that is the public interest. And if he is behaving by his omission or commission in a manner detrimental to the public interest, then he can be removed. That is what is clearly mentioned in section 7, subclause 3.
Thank you about that. Vaishali, do you have anything to add here?
What I feel is that as my colleague, sorry, I didn't catch your name, first name John, is it?
No,
Sorry.
Joseph.
As he's rightly pointed out, the roles and responsibilities of every IC member. An inactive IC member is somebody who does not follow what has been this
Yes.
duty or obligation under the Act. And I think an IC member or the IC committee is what is expected out of the committee, that it has to be vigilant, it has to ensure that the policy is working, it is a safe workplace, have regular quarterly meetings and have a deliberation on, what is. Sometimes I feel all ICs are happy that no cases are getting reported. And I always tell my IC members that actually that should be a sign of worry, that why are not people reporting? So are you active about really keeping the workplace? And there could be various ways of doing it. The moment management feels that it is just a paper compliance and the management is really actively wanting to pursue ICC doing its role, I think the best way of the management going about it is to replace IC members. Maybe give them a show cause, and say, or ask them to conduct quarterly meetings, or ask them to proactively do things, because they are a committee which is independent, of course, of the management once the appointment is done, but the appointment is in the hands of the management.
Right.
So functioning is something that needs to be looked after by the management, because the non-compliance is going to get the company in a soup.
Yes. So that's the worry, I think, of this organization. And that's why this question has come up. Thank you, Vaishali and Jobson. Vaishali, I come back to you again. Can IC consist of third-party consultants rather than direct employees who are well versed with the subject matter? Maybe the employees who are there, who are senior people, are not that well versed, but there are third-party consultants who are well versed. Can IC consist of these members?
So mandatorily, an IC needs to have a person called an external person, and external IC member who either comes with a legal background or comes with a background of working in the areas of violence against women. So that's a requirement of the law itself. Now, other than the external member, you can't have any other member. So for example, you have a member from the NGO working for women's rights. And if that external member is not very well conversant with the legal process of how to conduct an inquiry, how to frame a charge, how to write a recommendation or a reasoned judgment, at that time, can you invite a consultant or a lawyer to do that? My answer is no, because it directly affects the confidentiality obligations. So you can't have one more. I have seen cases where people reach out to consultants asking for an opinion, and people have reached out to me also. So at that time, what I try to do is I tell them that you will not disclose any of the parties' names. You will redact all personal information from the information that you are sharing. And my opinion could be based on mere, communication that you have done without on ensuring that there is no non-compliance of a confidentiality undertaking. But I personally feel that this practice is not a good practice.
So Vaishali, let me clarify, maybe I was not clear when I mentioned. So instead of your internal employees, okay, external member is there, but instead of your direct employee-employer relationship, in IC, like a presiding officer has, as per law, has to be an employee. So instead of her, if we have a third-party consultant who's been consulting us over a period of time, okay, we don't have an employment relationship as in, direct employment, but we pay her consulting fees, and can we have her as a PO? Can other members be a third-party consultant rather than a direct employment relationship? Sorry if I've not phrased.
No, sorry, no, maybe I heard it a little wrong. Then I'm sorry for that. I'm not even going into the provisions. Let's take a common sense view. The moment you say internal, there has to be an employer-employee relationship between the committee member and the employer. Because it is internal to that organization. The moment you look at consultants, professionals, experts, the relationship is not of an employer-employee, but it is a contractual relationship and no longer internal.
Right.
And then those are actually external members. So they may all qualify to become an external member, but not part of your internal committee. Otherwise, your entire committee is an external, made of external people.
No, again, that I don't recommend, Vaishali, for them also to be external member, because they have other relationships. We would want to keep an external member completely external who's only there for your PoSH committee. Yeah.
Yes, that's right. I totally agree that an external has to be purely external.
Yeah. Without
any conflict.
Yes. Jobson, you have to add anything here, or you think it's?
No, that's fine. If you need any clarification, then I can speak. Otherwise,
So I come to you on my another question, that on the basis of Section 18 of the Act, can employer in its service rule of PoSH policy assign disciplinary body or ethical committee as an appellate board in case either party is unhappy with the verdict? This came in one of our external members group where they were discussing and debating about this. I had an opinion, but I saw different kinds of opinions. So I thought, let me table it here to hear what the two of you think.
See, the appeal provision in section 18 is a statutory provision which mandates that appeal may be presented to the court or tribunal in accordance with the provisions of service rule applicable to the said person, or where no such service rules exist, then without prejudice to provisions contained in any other law for the time being, the person aggrieved may prefer an appeal in such manner as may be prescribed. Prescribed means as per the rules. And the appeal is to be preferred within a period of 90 days of the recommendation. Now, before this, they have written something else also. Any person aggrieved from the recommendations made under subsection 2 of the section 13 or under clause I or clause clause 1 or clause 2 of subsection 3 of section 13 or subsection L or subsection 2 of section 14 or 17 or non-implementation of such recommendations. These are the conditions where appeal has been prescribed for. And the usage of may is not to choose the forum, but to choose the remedy of appeal. If you want to prefer an appeal, you may prefer, but that appeal should be to a court or tribunal in accordance with the provisions of the service rules. For example, if this is pertaining to a tribunal, what we call a service scenario where the central government industrial tribunal or the central administrative tribunal, CAT or CGIT, these are tribunals. If the workplaces are pertaining to, then the appeal shall go to such tribunals. And if they are not falling into any categorized organizations, then it will go to court, like for example, labor court, or here it will go to the magistrate court when there are no tribunals. If it's an administrative, if it's a central government service or a central government industrial service or administrative service, then it will accordingly go to the CAT or the CGIT or even the state administrative tribunal. Like you have Maharashtra. In Maharashtra, we have MAT. So that is the appropriate tribunal where the appeal has to go. And these are statutory provisions which are to be mandatorily followed. So the appeal cannot go to anywhere other than what is prescribed here.
All right, thank you. I think I was of the similar opinion, but I heard 2-3 other opinions. So I said, let me, anyways, 2 days later, I'm going to speak to you. So I just held my thought process. Vaishali, you have anything to say, or you think that's good enough?
No, nothing to add. It's a very, very valid discussion about where does the appeal lie. There's a lot of confusion between, and there are internal appellate committees, yes, which cause more damage than anything else, because you're eroding into the limitation time.
Yeah. I think more than anything, organizations do not want it to go outside. So they want to provide all whatever platform they can internally. And I thought that is the thought process when they're creating internal appellate bodies. All right, Vaishali, I come back to you. In an organization, in the organization where we have disciplinary committee, does the IC just investigate the complaint and forward the findings to disciplinary committee to advise recommendations?
No, then that will be again dual, you're getting like one committee into the other, and no, that's a lot. That will be a lot of, it will be very confusing. So the law very clearly says that the internal committee will be formed as per the legislation to purely look into sexual harassment complaints of an aggrieved woman employee.
Yeah.
Or an aggrieved woman, I'm sorry, not an aggrieved woman employer, or an aggrieved woman. Which has been where the perpetrator is an employee of the company.
Yeah.
No other committee has the jurisdiction to look into a PoSH complaint, not even HR committee, a committee by any other name. It only, the exclusive jurisdiction is with the internal complaints committee or the internal committee. and it has to give recommendations directly to the management. There are no middle people here.
Yes.
And there is no oversight on this. It's an independent body. Even the management cannot interfere into the committee's inquiry process, influence committee members, influence the decision. The management shall implement the recommendations which have been given by the committee. It is like as clear, it can't get clearer than this. There are no additional people involved here.
So Vaishali, that gets me to a very interesting conversation once, where we as an IC were almost coming to the end of the giving the recommendation, and we were doing the report writing. Recommendations were given, and then accordingly we were doing a report writing, and we were taking some time to do that. The CEO of the company decides to call me, right? And he says that I want to meet you with the IC members. So I'm like, okay, what does he want? And I said, okay, let me hear him out. And we got into a discussion, and I realized that he's already been told about what the recommendation is going to be. And he was trying to ask us, why are we going towards X and why not Y? And he was advising us why is the right thing to do. So I had to actually step away from there, and I said that, I don't think, I didn't say in as many words, but I said it saying that you don't have a business to be telling us what it's IC and IC have decided. But I realized that IC is also a little lopsided now because the CEO thinks this way. Now, as an external member, do you think I have a role to do anything here? Okay, where we have decided a recommendation, we're just compiling the report. And now comes the CEO, and now IC is like, okay, I think the X recommendation is better than the Y.
Yeah, so each IC member has one vote, and each can give an independent decision. So we can understand from an employee's point of view, they really don't want to go against, which is not right. I mean, but that could be a mindset that you want, your job is very important to you. And that could also be for an external member, which is very wrong, that this assignment is very important to me. And I think that cannot be an external member's mindset at all. So as an external member, you can stick to your view. If it could be a completely contrarian view to all other IC members, but at least it comes on record that you have given an independent thought and an independent judgment, perhaps at the cost of your contract not getting renewed. But you've been true to your calling and said that, no, I will not change my opinion because based on this evidence, irrespective of what others think, this is my judgment.
All right. Thank you, Vaishali, for that input. I come back to Jobson. In a PoSH case, the ownership of providing evidence is on complainant and respondent. Is this statement true? Does PoSH panel need to take a role of police and get GPS data and phone records, etc.? Sorry about laughing at it, but it was very funny. It made me think like Jagga Jasoos I have become. Jobson, you're on mute.
Unmute.
Yeah.
Yes, your question was about the onus of proving.
Yes.
Yes, it's a cardinal principle of law that the onus of proving an allegation has to be on the person who makes the allegation.
Right.
But at the same time, it becomes the duty of an organization to look into the very root of the thing, because as you say, when you constitute an inquiry, like a committee sits and all these things are done, it takes a lot of time and effort of the organization. And if such things are repeated or being repeatedly done, then it is not in the best interest of the organization. So therefore, in such a situation, the organization also should take a proactive role in going to the root of the case by, on its own to get a few things proven within the within the boundaries of the law. When you say you take in the using GPS or to tracking the phone call and all these are illegal things. You cannot do it. but being within the, boundaries of the law, whatever possible to collect as much evidence as possible, it could be done in the best interest of the organization. But of course, the onus of proof is always on the person who is making the allegations, and the woman has to do her bit to prove her allegations. Otherwise, there is a section directly provided to attack her if the complaint is found to be without any material or found to be malicious.
Found to be malicious,
Yes.
primarily. Vaishali, do you have anything to add to this? You think there are clients who tell us that we can go and see whether this happened. We can see this person coming out. All these things, they would want to assume the role of
As an investigator.
private detector.
Yes, yes.
You're on mute, Vaishali.
Yeah, so we can't be jaga jasuses how much ever you want to be. Sometimes it also happens in good faith because you know that there can be evidences, but it can be done only at the instance of the complainant or the respondent. So if the complainant says that please retrieve the CCTV footage in the canteen area of a particular date at a particular time, then the committee has the power to ask for a CCTV footage, either from their own premises or even from an external premise. And that is where the civil powers come in. Or if this lady says, see, I did send that email and I did receive that email, but unfortunately in my inbox, I can't see it anymore. And obviously the respondent is not cooperating by giving the email printout. At that time, the email can be got from a third party intermediary by an order in writing by the IC. But that can be done. So evidences from third parties can be collected only when the parties want us to do that, not on our own.
All right, great. Thank you. Now I'm going to take some questions from the chat here. I see loads of them. Oh my God, I see many of them.
Sorry, like I have answered some. I didn't know that this was going to taken up later.
No, perfect. Because anyways, that would be really helpful. So one which has come directly to me is, once complainant opts for inquiry and inquiry process is on, can complainant opt for conciliation? I think we spoke about it, right?
Yeah, once inquiry starts, you can't go back to it. Conciliation. Short answer.
Yeah. All right.
It's a contrasting view.
Yes.
Oh, is it? Sorry.
No, it's okay. It's okay.
No, I mean,
I'm of the considered opinion.
What I hear is it can happen that once the inquiry starts, there could be again a form of a negotiated settlement.
Yeah.
This law actually does not really provide for that, because it has placed the conciliation section right before the inquiry and says that before the inquiry process starts, get into this. Now, what happens in an inquiry? It may happen that there are findings, say, of a malicious complaint. The complainant realizes that there's so much evidence coming in that she will be held guilty for filing a false complaint. And that time, if she says, no, now I want to settle, let him just give an apology letter. Then what will happen? The rights that are getting accrued to a respondent for initiating this process of punishing her for a false complaint, they can be taken away under conciliation. And that is why I feel once this option of conciliation is not availed of by the complainant, she should not be given that option once the inquiry starts. Because I think what Jovson was saying, and which is very right in terms of all other proceedings, is because both parties have an equal right of conciliation. In this law, only the complainant has a right to ask for conciliation. The respondent never has a right. Is my view on this.
All right, two great views.
No, see, the section 10 of which provides for conciliation in subclause 4 says, where a settlement is arrived at under subsection 1, no further inquiry shall be conducted by the internal committee or the local committee as the case may be. Then section 11, the second last proviso says that provided that where the aggrieved woman informs the internal committee or the local committee as the case may be, that any term or condition of the settlement arrived at under subsection 2 of section 10 has not been complied with by the respondent, the internal committee or the local committee shall proceed to make an inquiry into the complaint, or as the case may be, forward the complaint to the police. Provided that where the parties are employed, the parties shall, during the course of inquiry, be given an opportunity of being heard, and a copy of the finding shall be made available to both the parties, enabling them to make representation against the findings before the committee. So in these two provisions, there is no bar against a conciliation pending an inquiry or a conciliation in the midst of the inquiry. On the contrary, the proviso and the other subclause stipulates a situation where such a
So if I can just like add a little bit, I
Yes.
hear you, Joseph. I think what my interpretation of that section is that once the complaint gets filed, the complainant, as I said, there's an unequal distribution of rights here. Only the complainant gets a right to seek a conciliation. See, so a respondent also can come and say that let's explore an amicable settlement. Are we going to allow him that? No, because section 10 doesn't allow that. Section 10 says only the complainant can avail of a conciliation. So even if the respondent wants it, we can't give him that unless and until complainant wants it. That is step number 1. Now let us assume a settlement happens. The settlement is that he will ensure that he does not travel in the same company bus that she does, like after every shift is over. That is their settlement, let us assume. And it happens for 1 month, it happens for 2 months. And the 3rd month, she realizes that he started coming in that bus again. That time, she can reopen the inquiry, is what the proviso is. She can say that there was a settlement, he did not adhere to an undertaking which he had given in the conciliation. Now I want a full-fledged inquiry. Again, it's an unequal right. The respondent can never go back and say, I still want an inquiry. All he can say is, I don't want a conciliation. Complainant may say, see, I want him to terminate, I want him to resign, and that's the end of this complaint. He can say, no, I'm not resigning. Let's go to a full-fledged trial.
Yes, the accused or the respondent cannot have the right to seek for a conciliation.
That's the inequality here, which is a
he can suggest, and then she may say, yes, okay, I'm willing.
Well, I mean, is it a suggestion or is it then influence, undue influence?
It might be a help.
I think it's two great opinions. I think when we get there, debate this out. Actually, even till now, when I would practice or I would recommend, I would say that once we have started a full-blown inquiry, we wouldn't take a U-turn. And that has been a thumb rule. I hear it's a great perspective for both the sides. So I think we'll go ahead because there are loads of questions and we are stuck in conciliation, right? So the next question I read here is, what if employees are witnessing a woman evidently being supported all the time and others not getting enough opportunities or equal treatment like appraisal, promotion, tasks, decision-making, etc.? One getting all the privileges and others' efforts being ignored. First of all, is it sexual harassment? Can it be reported under that?
If the woman has no complaint, then you can't.
No, these are other people.
Other people.
This woman is getting a preferential treatment. while the others either are not getting any preferential treatment or getting detrimental treatment, or maybe not, they're being ignored. So
the protagonist, the protagonist in the act is aggrieved woman.
what if it's a woman? Yes.
It's if the woman is aggrieved by this special treatment, that is, she's getting embarrassed in front of her colleagues, that only I am getting it.
No. This is not the person who's getting preferential treatment is complaining. Others are complaining.
Others have no locus standi. That's my view.
I have a slightly different view, sorry. I think such behavior needs to be called out, not before the IC committee, but there are several other committees which can look into it, because we are talking about a safe workplace and an inclusive workplace which is free from any form of discrimination, which includes preferential treatment. So the people who feel that they are aggrieved because one particular female employee is getting a preferential treatment by our manager, including perhaps appraisals which are undeserved in their view, this can be raised under either the ethics or the code of conduct policy before the right forum. It could be a disciplinary committee, it could be a code of conduct committee, it could be an ethics committee. I'm sure there will be different, not under PoSH. I'm not saying it can come under PoSH because that is not sexual harassment. This is perhaps a very classic case of discrimination without a sexual overtone. But it is still discrimination, it is still unequal treatment. And you can't, I personally feel you can't say there is no solution for an unequal treatment.
No, I was talking about the PoSH Act. This act is not applicable in this situation, I was saying.
That's right.
There is no locus standi under this act, I was.
But at the same time, this behavior needs to be called out.
Yes. There are ways for that.
So if we have another question, if we have a legal department, whether our employee can be legal IC member. I think Rajita's question, I think what
employee can be IC member,
yeah,
not a legal IC member. She or he will take the color of IC member.
Internal IC member.
Internal IC member. Yeah. That because if she or he is from the legal department, she doesn't bring her legal role in it.
Yes.
She may be better equipped, she or he may be better equipped to understand the legalities. That's one thing, and that's a great advantage also. Yeah. But he or she is not there because she's from the legal department.
Yeah. Another question Rajita is asking is the IC members will remain for how many years? Is there any renewals?
So 3 years is what the law is saying. And I have seen renewals happening because there's no law which prohibits renewals. So renewals can happen.
Great. Another one, so clearly renewals can happen, and there are people who leave and then come back, maybe take a gap and come back also. There is another question which is sent directly to me. What are the recent legal development or changes related to workplace harassment and discrimination as per law?
Very wide question.
Very wide question.
Very wide questions. So maybe I just quickly add a line.
Write a blog on it, I think.
So the developments are through judgments or precedents. The law really hasn't undergone any amendment as such. There's not been any clarification, or we all know there are certain loopholes in the law, and we're hoping that they at some point of time get clarified. But there's no amendment to the law as such. But there have been so many precedents, which I can quickly think of is all the courts are very consistently saying that if the IC have followed all the proper procedure which have been laid down under the Act, merely because the verdict is an error of judgment, the IC can't be hauled up for not doing their job, or that will not stand in an appellate court. The courts will not interfere with the reasoning of the committee.
Okay.
The courts will generally interfere only if they've not followed proper procedure, say principles of natural justice. Those are the grounds on which the appeal may stand. If it is a mere error in judgment of recommendation, or if they find the punishment is too harsh, it could have been lesser, the courts will generally try to stay away from that.
Wow. Wow. Great. So what it mainly means is that we have to ensure that we follow the correct process, and we take it to the closure properly by ensuring that we have done, it shouldn't be just tick in the box, but generally following the entire process.
So, Smita, if I could, because it's a very important point, and because you just highlighted that, let's take a very simple example, because I know all ICs are in a hurry to close.
Yes.
So 90 days, no, let's not give him like 5 days, and this, whatever is the statutory period. So they'll say, okay, 10 days to respond. No, it's 10 days, no, to file a reply.
Yes.
10 working days. So on the 11th day it doesn't come, immediately you want to post it for evidence. So sometimes I tell the IC that right now it is better to give him an extension, rather than later on him saying that I was not given adequate opportunity.
Absolutely.
Because that's a classic ground for an appeal to be allowed.
Yes.
And re-inquiry after, say, 2 years.
Yes.
So sometimes the procedure, it may seem very, it's a very simple statement to make, but it's very important to follow it to the hilt.
Absolutely. I get this a lot from IC members saying, why do we have to do cross-examination? Why do we have to send their documents to each other? They have known it, let's just go ahead and close it. That kind of pressure, but we came back saying, no, this will come biting back if we don't do it right just now.
Or sometimes I've also found this very funny practice that they'll say, we'll send them an extract.
Yeah.
Of the written statement, or or we will remove certain paragraphs which has allegations about other people.
Yeah.
But that also we can't do. You can't touch the reply.
Yes. Very important. Dr. Usha Pantula has made a profound statement, and I would like to quote it here. SH is not always about sex. It could be about power.
Yes.
That's so true.
In my view is that in India, rape is not a sexual offense alone. I mean, it's not always a sexual offense. Similarly, sexual harassment is also not always for sexual reasons. It's a way by which a woman can be harassed very easily. To harass her sexually, give her a feeling that she's being sexually harassed, without there even being an iota of anything sexual in nature. Yeah. Just give her a fear like that. And it is always, as Dr. Usha raised the query, it's more often it is like, it's like somebody is, asserting their power or dominance on certain class. If you look at Vishaka's case, Vishaka case is not about sexual violence. It is about class domination.
Absolutely.
A woman from a lower caste.
How dare she talk?
Yes, to teach her a lesson, this men taught her, the way this happens only in India. Maybe in US, black against white, white against black, this might happen. But in India, if you see the statistics, most sexual offenses are for the purpose of asserting the dominance of one class against the another.
Absolutely.
That's the.
I think Nirbhaya was so brutal because the strong woman tried to fight back strongly.
Yes, yes. That is why one of the so-called godmen, one of them who is inside, behind the bar, he said that she should have simply said, "Behan samajh kar maaf karo."
Yes, yes. Massage their ego. God bless us all.
Yes.
Okay. So another question is, when women work at workplace, force by senior management to tease other employee deliberately. So it's also come in PoSH. I didn't understand when women
Yes.
work at workplace. Swapnil, you would want to ask that question. I didn't understand this question. In the meantime, there's another question by Dipali. Where can we get recent judgments on PoSH law? Dipali, we have a lot of it on our website. We are collating it also. So we can share with you. And I think we are overstepping. I'm sorry, it's 5:05, but the discussion went over and the team had to ping me saying it's 5:05. I didn't realize. Oh God. All right. I think I had a great discussion with the two of you.
Can I have a one final question, Smita? Is it okay?
Yes, doctor. Go ahead.
Yeah. Is it mandatory for the internal committee to maintain minutes verbatim of the depositions by the respondent or the aggrieved woman or the witnesses? Is it mandatory by law?
You want me to answer that?
Please.
Yes, please, Vaishali ji.
So when you say a deposition, it is about what the witness has said before the committee. So an ideal situation is the way depositions are recorded in court. They have to be recorded verbatim. So ideally, you could have a steno to do that, and sometimes confidentiality agreement, and then he there and there records it, and at the end the need to sign off saying that yes, this is the deposition that I gave and this is my signature in front of all the it is also better to do that later on, that I didn't say this or you didn't hear it properly, that I never said it.
I think
So it is best.
Vaishali,
And anyway, the recording.
We are losing Vaishali, right?
yeah, we are losing her. So, doctor, I will summarize what she's trying to say. She's saying that it is important that we have a deposition from her, and if possible. So, doctor, I'll tell you one thing. A lot of my clients who are in IT have started using artificial intelligence to capture the verbatim, and it is brilliant. I'm so impressed by artificial intelligence, the way it is capturing verbatim, and really, really good. Like earlier, it used to be all garbled, but now amazing output is coming. I know stenographers are very few and very, they have become specialized skill set. We don't find them in market. So it's a good idea to use artificial intelligence. We also take down, in fact, we do a video recording and video transcription immediately. So we get it. We just look at it or read it once to remove any scrap and send it to the complainant or respondent to sign off. So that's the best practice, and I think we should do it. That's what she was trying to say.
Thank you so much.
Doctor. Thank you, Jobson. Thank you, Vaishali. I think it was amazing conversation, some contradicting thought processes, but which is great, which gives us more food for thought, which only sharpens our rough edges. Thank you very much for your time. Any closing statement from the two of you? I don't know if we still have Vaishali, but Jobson, anything from you?
Yes, as far as law is concerned, you must understand that a single copy of law, the statute, is interpreted by two different lawyers in two different ways, and the judge gives the third interpretation. And when it goes into further appeal, it might have another interpretation. So law is always subject to interpretation. So it all depends on how ultimately which interpretation is upheld. It's called the set law, or this is the position of law. This is how lawyers say. When you lose a case, we tell our clients that is the position of law. So that's how it is.
I had a wonderful time. Thank you all and for this opportunity. Nice meeting you, Jobson. And
Same
thank you,
here.
Smita.
Thank you, Vaishali. We lost you for few seconds, I think, but we
I realized, but I listened to your, that update, and it covered everything. Thank you.
Thank you. Thank you so much. Take care of yourself. Have a lovely evening and the year ahead. Okay, we'll
Same
keep
to you,
meeting every
Smita.
month. Thank you so much.
Thank you, everybody.
Thank you all.
Thank you. Bye.
Good night.
Good night.